the fundamental rule on state aid is this, that state aid is initially, at any rate, declared incompatible with the common market. A slightly different thing from being declared prohibited. But the effect is that unless it is approved by the Commission, or very occasionally by the Council, as being compatible with the internal market, then it is effectively prohibited. So and there are these four primary conditions that must entail financial advantage from state resources. That must be a selective advantage favouring certain undertakings. There must be a distortion of competition and an effect on trade. Sorry, I'll get this right yet. Then we have the broad exemptions. State aid has been with us for a very long time. In fact, since the original EEC treaty came into effect. Over the years, the most important way of declaring it compatible with the internal market was on the basis of what is now Article 107.3c, which allows for aid which is to facilitate the development of economic activities. Now, that facilitation implies that the development wouldn't take place without the aid, and the development implies that it's a form generally of investment aid. So it's something which will help develop an economic activity or an economic sector or an economic region. Over the years, the Commission had narrowed that down to those following subcategories of permissible aid, being regional aid, aid for small and medium enterprises, research, development and innovation aid, environmental aid, and training and employment aid, all of which are covered now by a block exemption, which sets out the basic rules, and those that don't fall within the block exemption might be covered by slightly wider guidelines. But the basic rules are all set out there. They allow a fairly rigid control, fairly strict control for the quantity of aid. Depends on certain things, but by and large we could effectively say investment aid is normally limited to 15 to 20%. It may be higher in certain circumstances. Generally it's around about 15 to 20% is permissible. The one fly in the ointment was always rescue and restructuring aid, because that nearly always involved very large failures of a large company. Alstom in France, British Nuclear in Britain, and a few other really big multi-billion-dollar failures of companies which had massive strategic effects. There were many other restructurings carried out over the year, but each year there were usually a few major restructuring problems. Anyway, all that allowed the Commission to take action. We then had the credit crisis, and that it started off the Commission using the restructuring guidelines under what was then 87.3c to deal with the credit crisis. But that proved to be not sufficient for the simple reason that the restructuring guidelines applied only to firms in difficulty. But with the financial crisis, that included also banks which themselves were economically sound, effectively sound, but which couldn't get funding or couldn't get liquidity because the market had dried up. So that all started to fall apart. And as we saw, the government started to weigh in with massive amounts of aid. Now, before moving on to what the Commission did, what could have happened at that stage, what just might have happened if the Commission had given the impression that they were going to be fairly rigid and stick with the original restructuring aid guidelines, the possibility was always there for the Council, that is basically the Member States, to step in under what is now Article 108, paragraph 2, where they can provide aid, they can approve aid given by Member States in exceptional circumstances. Without doubt, this was an exceptional circumstance. The trouble is, once the Council would start in to approve the aid, the control moves away from the Commission into the hands of the governments. And of course, if the governments had been left to run riot, determining what aid they were going to approve, it would have been a roundabout series of you back our deal, we back your deal, everything's unanimously agreed. That would have been the problem. So the Commission instead moved in and adopted the procedures under Article 87 3b, which allows for aid in the context of a systemic economic failure or difficulty. and we'll come to this, the repercussions of that in a minute. Can I just briefly look at the supervisory procedures, because they're also important to have a grasp at the background of what they are. The supervisory regime, if you're within the block exemption, then the aid or the system of aid is automatically permissible. Otherwise, aid must be notified to the Commission in advance under Article 108, paragraph 3. And then we now have the procedural regulation, been in place for 10 years, which governs the system. In fact, it really reflects the system that had always been there, but it lays down detailed rules. There are two stages. Well, there are meant to be two stages. In fact, as we'll see, there's a third stage now. The two stages are meant to be that aid is notified to the Commission. The Commission carries out a preliminary assessment. It can then determine that the measuring question actually doesn't amount to aid at all, or that it's aid but is clearly compatible with the common market, or that the Commission has doubts as to its compatibility. If it has doubts, it cannot clear the aid at that stage. It must move to the next section, or the next assessment stage, which is the formal assessment under Article 7 of the regulation, and Article 88.2 or 108.2 of the treaty. Now, the difference between the preliminary assessment and the formal assessment is at the formal assessment stage, the whole system opens up. During the preliminary assessment, the dialogue is between the member states on the one hand, or the member state granting the aid or wanting to grant the aid on the one hand, and the European Commission on the other. Nobody else is technically involved at that stage. Once it moves into a formal assessment, on the other hand, what happens is that the Commission places a notice, a summary of the proposed aid in the official journal. It says why it has difficulties in terms of its assessment as to compatibility, and it invites comments from third parties. That allows third parties to come in at that stage and be involved formally in the process. At the end of that investigation, the Commission can then come to a conclusion either there's no aid, or that there's aid which is compatible with the common market, or it can attach conditions to the permitting the aid, or it can simply say the aid is incompatible with the common market and cannot be brought into effect. Now, I mentioned that there was a third stage creeping in, and that is a pre-preliminary stage, in fact, has now crept into the Commission's processes. It used to be that member states would sort of notify the Commission and say, here it is. That would engage the Commission, they'd start talking. The Commission itself issued guidelines last year, a best practice notice, when it encourages a pre-preliminary assessment discussion with the member states, so that the member states get involved in discussions. They show the Commission what they intend to do, and they can talk to the Commission to say, do you think this is okay? Do you think there's a problem here? The Commission can say, these are the areas where it will present a legal or an economic or an assessment problem. The member state can then change those so that by the time it comes to make its notification, the Commission has already said, informally, technically, we think that if you make the notification on those grounds, we will approve the aid. That means that you only then have the preliminary assessment. That means there is no element of third-party input into the assessment. And that is, in fact, what's now beginning to happen to quite a few, in fact, quite deliberately. I mean, the Commission has aimed to change its procedures to allow for that. So we then had the systemic crisis, which was dealt with under 87.3b at the time. Stan has set out the various different communications which came into effect. Just give you one example of how these sort of fudged the issue. The temporary framework, for instance, it's a framework allowing certain types of aid, enhanced aid for the next, to the end of this year, to the end of 2010. One example was that we have in the general system of state aid law, we have a de minimis rule whereby aid can be awarded up to €100,000 over a 3-year period to any individual undertaking. The member states in the early stages of the crisis went to the Commission and said, look, 100,000 is simply no good. We want to be able to, or some of the member states said, we want to be able to award up to $1 million. And apparently, it must have been over coffee or something, they simply split the difference, and hence there is a figure in the temporary framework whereby member states can grant up to 500,000 euro to any individual company over a period of 3 years. So there was a sort of give and take between the Commission and the Council or the member states in terms of what they were going to allow over that period. And obviously the rescue operations communication was valid at the time. I'm not sure if it is still running in real terms. It might be, I suppose, to some extent. But obviously the two main areas are the treatment of impaired assets and the restructuring measures, or recapitalization was an earlier version of the restructuring measures. But what I want to talk about is to move away. Stan has set the scene of what the Commission has actually done. What I want to do is just give a few examples in the minute or two that's left to me. And obviously I couldn't stand here and not mention NAMA. So I'm going to look at NAMA, I'm going to look at the Lloyds banking group in the UK, and the bank payroll tax, the banker's bonus tax. Just give you a flavour of not just the narrow approach or at least the narrow application of the state aid rules in the context of the financial crisis, but also to show how things maybe develop a little broader than that. First of all, we have the normal definitions of what are an aid. It's an intervention by the state resulting in an advantage for an undertaking by mitigating the charges which are normally included in its budget. That's a very old definition, but one which is still the standard. The second one is the recipient receives an economic advantage which it would not have obtained under normal market conditions. And then the third is a departure from a benchmark set of rules or from a normal burden which confers an advantage. If we look then at the market, what's called the market operator test, and this is obviously NAMA's maybe in the background here when we think about the system that is set up here. Last Sunday's, one of the reasons I decided to put this in, last Sunday Business Post, the front article on it gave the impression that the argument was, in terms of NAMA, was still whether the government or NAMA buying or taking in these loans, these bad loans, including this excess value, this extra 15% value, means that it is or is not state aid, and that was the toss. I was rather surprised, I have to say. I mean, I haven't been involved in NAM at all, so I don't know, but I was rather surprised that was the way they put it. Because clearly, if the test is, would a private operator in possession of the same information as the public authority conduct the same commercial transaction on the same terms? And if one looks, in fact, also at the impaired assets guidelines, that specifically says that the market value is the present market value. It then goes on to say that you can take into account the long-term economic value of the products, but that, according to the guidelines, is an issue relating to the assessment of the compatibility of the aid with the common market. And that's a very important distinction. In other words, you're not saying you can take long-term economic value into account to determine what is market value. Market value is today's value. But then taking into account this long-term economic value is a question of what is the quantity of aid and is it proportionate? So that's a rather different issue from what the Business Post seemed to be saying was the issue. I better skip over this very quickly because I'm afraid we don't have much time. Then we've got the restructuring guidelines, which and the recapitalization guidelines. Stan mentioned and went through at some depth the issues of why we have those and went through the various criteria, including the need to sell off some assets in order to make first of all, it makes the company leaner, or the bank leaner, hopefully more competitive. But also there's a long-standing notion in state aid law that there should be a compensatory measure. In other words, if you're given state aid, you should be given something back. In this case, what's given back is selling off a substantial whack of the assets of a bank or insurance company which has received the assets. There are two major ones. I think ING. Did you mention ING? No, you didn't mention it. ING is a Dutch company that was a huge company, received huge aid, and it was required to sell off a proportion or a slice of its assets, and that was with a view to opening up the retail banking market in the Netherlands. In the UK, the same thing has happened, and it's happening specifically with RBS, the Royal Bank of Scotland, and the Lloyds Banking Group. But it's slightly different, and the slight difference is this. In Britain, about 80% of the personal accounts market, the retail banking market, is dominated by four main banks. That's the Lloyds Banking Group, which is Lloyds TSB plus HBOS that they rather foolishly bought. Then the Royal Bank of Scotland, Barclays, and HSBC. They have about 80%. The other 20%, you've got Santander, the Spanish bank, which is moving into the UK, has bought up a significant slice. And the Nationwide, which was a building society, I'm not sure if it still is only a building society, but I think it has a banking arm. Then you have the other smaller ones. Now, the intention in the RBS and Lloyds Bank case is that they must sell off. Lloyds has 29.5% or so of the retail banking market. They have to divest just under 5 percentage points of that overall market. In other words, 20% of their business. Similar as in the ING case, and RBS will have to do the same thing. But what the government did not want was as what could be termed shifting of the deck chairs. They didn't want just another big bank to go and buy up this 5% share of the market, because that wouldn't open up the market to competition. So they have been using, and the Commission has put in to their decision approving the aid, a condition that the aid, that the slice, the 5% slice, will be sold to a company that has a market share of X percent, and X percent is not, as far as I know, public. But the intention is that it will not be sold to one of the big boys. It'll be looking for either a new entrant into the market or one of the smaller players. The intention being to try to use this state aid system as a means of opening up the retail market. Rather than simply downsizing one company, it is to ensure that not just that one other company gets bigger, but that there are other additional players in the market. Finally, and I'll finish on this point so we have some time, is the issue of state aid taxation. A very, very complicated area, the interaction between state aid and taxation. We've had the red lines in the treaty negotiations, the Lisbon Treaty negotiations, clearly saying tax is a matter for the member states, which is very true, but then that is always subject to the state aid rules, as it is to the free movement rules. The difficulty here is, on the one hand, a government wants to apply a tax. Think of a new tax, such as the banker's bonus tax. It imposes that on banks by reference to bonuses paid to their employees. The trouble is, what it doesn't do is impose a similar taxation burden on others who are providing similar economic activities but which are not classified as banks. And there's no doubt about it that to some extent there is an overlap between what we call in the jargon non-banks do. That might be hedge funds, it might be other types of providers of financial services. The question is, are they, from the top thing there, does the measure constitute an advantage for certain undertakings in comparison with others which are in a comparable legal and factual situation? If they are in a comparable factual situation, comparable business economic situation, then taxing one and not taxing the other theoretically gives rise, and maybe rather more than theoretically, gives rise to a state aid to the non-taxed activity. And that's an issue which I think has to work itself out in the context either of the BPT, the bank payroll tax in the UK, and in the context, which because it'll be much wider scope, the proposed international levy on non-insured activities of financial institutions. And I better say no more about that for the time being, but I'll wrap up on that point and take my seat. Thank you very much.